Okay, so today we are diving into a legal case, and honestly, it's like, whoa, this is dense stuff.
Yeah, it's a big one.
We're talking about GR No. 135-385.
Right. A Supreme Court case really gets into the heart of the Indigenous Peoples Rights Act of 1997, IPRA.
IPRA, we've heard that one before.
Right. A lot of debate around it, and this case really brings it all to the forefront.
And you've given us a stack of stuff.
Yeah, I figured go big or go home, right?
Legal documents, historical analyses, even parts of the case itself. It's going to be quite a deep dive. Where do we even start?
Well, to really grasp this case, we got to go back in time, like way back.
Back to the beginning.
Before the Spanish arrived in the Philippines, imagine a Philippines where you didn't own land, you belonged to it, along with your entire community. That was the reality back then.
So different from how we think about property today.
Right. These villages, they were called barangays, almost like mini nations, each with their own ways of doing things.
Like their own little governments.
Exactly. Land belonged to everyone. The chieftain oversaw it for the benefit of the community.
No deeds, no titles, nothing like that.
Nope. Instead of written laws, they had customary law, rules passed down through generations by word of mouth. These customs, they governed everything about the land, how it was used, inherited, even how they resolved disputes.
That's fascinating. So different from today's world of contracts and legal battles.
Yeah.
Then, bam, the Spanish arrived. Things got messy.
Understatement. The Spanish brought with them this idea called jura regalia.
Jura regalia. Sounds impressive, but what does it mean?
Basically, all land belongs to the crown, the king or queen. So that whole communal ownership thing, yeah, the Spanish weren't so keen on that.
Talk about a clash of cultures. So the Spanish just claimed the entire archipelago as their own. What happened to the indigenous communities? Do they just have to accept this new system?
They didn't really have much choice at the time. The Spanish established their own legal systems, introduced land titles, formal registration, all that. They even had this thing called the Ley Hipotecaria in 1893 to make it official. And guess what?
What's that?
That system, with some tweaks here and there, it's still the foundation of Philippine land law today.
Wow, talk about a lasting legacy. But that system, it relies on written proof, right? Titles, deeds, all that. What about the indigenous communities who had relied on their oral traditions for centuries? How did they navigate this new system?
It was incredibly difficult, a real disadvantage. They didn't have the documents to prove what they'd always known, that this land was theirs.
It's like speaking two completely different languages.
That's a great way to put it. And this clash, it's at the heart of so many land disputes involving indigenous communities. There's this case, Valentin v. Murciano, back in 1904.
1904.
One party, they were claiming ownership because they've been living on and using the land for ages. The other party, they had this fancy government-issued title. The court sided with the title holder. It solidified this idea that in the eyes of the law, that piece of paper, that title, trumped generations of traditional occupation.
So even under American rule, same story, different ruler, did things change after the Philippines gained independence?
It was a slow shift, definitely not overnight. The 1935 Constitution, for example, focused on assimilation, trying to integrate indigenous populations into the dominant Filipino culture.
That didn't really address the root issue, did it? The land rights.
Exactly. It wasn't until the 1973 Constitution that we see a real acknowledgement of the rights of, as it calls them, cultural communities. The Constitution recognized their customs and how these should be considered when creating laws.
Okay, so progress, but was it enough?
Not really. They tried integration policies like this RA No. 1888 and 1957, but it still didn't click.
So despite good intentions, those policies still fell short.
They didn't address the core issue, ancestral land rights. You see, indigenous communities were still being pushed off their lands, their rights ignored, especially when it came to big development projects.
That's where IPRA comes in, right?
Yeah.
Trying to set things straight.
Yeah, IPRA was a game changer, at least on paper. It brought in this whole concept of ancestral domain, which is way more than just owning a piece of land.
Okay, so it's not just about having a deed to a plot of land.
Right. It's recognizing the deep connection indigenous communities have to their territories. Not just the land, but the water, the resources, everything. It's about their history, their spirituality, everything.
So it's about recognizing a whole way of life, a cultural heritage that's tied to that land.
Exactly. Within these ancestral domains, you have ancestral lands, areas that individuals or families within the community have held for generations since, well, forever.
Okay, so ancestral domains, big picture. And within that are ancestral lands.
Yeah, like a zoom in on specific areas within those domains. And that's where IPRA gets really interesting and introduces native title.
Native title. Okay, we need to unpack that one. What does that even mean?
Imagine ownership that existed long before any colonial powers. A right that's not given by a government, but woven into a community's very existence. That's native title.
So it's not about a government saying, this is yours now. It's about recognizing what's always been true for these communities.
Exactly. IPRA's argument is that these ancestral lands and domains, they were never the government's to give away in the first place.
That's a bold statement. It directly challenges the whole idea of juro regalia, the Spanish claim that the land ultimately belonged to them.
Yep, and to support this, IPRA points to an interesting case from 1909, Carino v. Insular Government. It involved this Igorot man, Mateo Carino. He claimed the government had wrongly taken his ancestral lands.
Carino v. Insular Government, 1909. This Mateo Carino, he took on the government.
He did. And this case, it's what legal scholars often call the foundation for native title in the Philippines. He lost in the Philippine Supreme Court, but guess what? He appealed all the way to the U.S. Supreme Court.
All the way to the top. What do they say?
They sided with Carino. The U.S. Supreme Court, they acknowledged that, yeah, Spain might have claimed juro regalia, but it didn't erase the pre-existing rights of indigenous peoples to their ancestral lands.
So a victory for Carino and a precedent that really challenges the traditional power dynamics over land ownership.
Right. IPRA leans heavily on this case to back up its claims.
It sounds like the legal basis for IPRA hinges on this idea. Native title predates the arrival of Western legal systems, making it an inherent right, not something granted by colonial powers.
Exactly. And this is where GR No. 135385 enters the picture. Two citizens, Cruz and Europa, they filed this case arguing that IPRA, parts of it, were unconstitutional. They thought IPRA went too far, especially in its definition of ancestral domains, ancestral lands, and recognizing them as private, communal property of indigenous peoples.
So we have a clash of legal titans. What were their specific issues with IPRA? Why did they think it was unconstitutional?
They were worried about the government's power, especially when it came to things like minerals and timber.
Resources, valuable stuff.
Exactly. They saw those as crucial for the whole country, for development, and they felt IPRA was giving too much control to indigenous communities.
So it's like indigenous rights versus national interests, right? Tradition versus progress. What did the Supreme Court say about all of this? Did they agree that IPRA was unconstitutional?
Here's where it gets interesting. The court, they didn't actually give a straight yes or no answer.
They didn't. What do you mean?
They issued a resolution, not a full-blown decision. They basically decided to hold off on ruling on the whole constitutionality of IPRA.
So a bit of a cliffhanger then. Why punt on the big question?
They got hung up on this thing called locus standi.
Locus standi. Okay, you're using the legal jargon now.
Sorry. Basically, it's about whether Cruz and Europa even had the right to bring this case to the Supreme Court in the first place. The majority of the justices, they thought this whole thing should start in a lower court. You know, follow the usual process.
So a technicality, a procedural issue.
Yeah, they were focused on the process, not so much on the big picture arguments about IPRA. But there's a twist.
There's always a twist.
Two of the justices, they weren't too happy about this. They wrote these dissenting opinions saying, hey, we should be addressing the heart of the matter.
Two justices disagreeing with the majority. Okay, now we're talking. What were their arguments? Why did they think the court should have ruled on IPRA?
Justice Vitug, he was worried that if they recognize indigenous ownership over these huge ancestral domains, it's like giving away a big chunk of the country.
Giving away power, too.
Right. Exactly. He felt that while, yeah, indigenous rights are important, they shouldn't completely override the government's ability to, govern, use resources for everyone's benefit.
A balancing act. Trying to find that sweet spot. Okay, what about the other dissenting justice, Justice Kapunen? What was his take?
Justice Kapunen, his dissent is really something. He went deep into the history, talked about all the time indigenous communities got the short end of the stick, how their customs and land rights were just ignored.
He was pointing out the injustices, the systemic issues.
Exactly. He saw IPRA as a way to correct that, a way to make things right, to acknowledge those historical wrongs.
A strong moral argument. But even though the court as a whole didn't make a final decision, did they at least address some of the legal arguments about IPRA? Or was it all just about procedure?
They did touch upon some of the legal stuff in their individual opinions. Like Justice Puno, in his dissent, he presented this whole defense of native title.
Okay, so even though no final ruling, we still get some insights into their thinking.
Exactly, like peeking behind the curtain. Justice Puno's analysis of native title is really insightful. He traces it way back to Spanish colonial law, even American law about Native American land rights.
So he's saying this isn't some new radical idea. Native title has roots, a legal history.
Exactly. He argued that by recognizing native title, IPRA is really just acknowledging a form of ownership that was already there long before colonization.
So IPRA isn't inventing something new, it's codifying something ancient. What about those who weren't so keen on IPRA? How did they counter that?
Good question. Justice Mendoza, for example, he agreed that, yeah, the Carreño case, it did support native title to some extent, but he thought it should only apply to certain types of land, like farmland.
So he's drawing a line.
Yeah, he didn't think native title should extend to things like forests or areas with lots of minerals. Those, he believed, should belong to the state. Jura regalia.
So recognizing indigenous rights to certain lands, but maintaining state control over resources deemed, too valuable, too important for national development.
That's the crux of it. And this difference in how they view the scope of native title, it's a huge part of the IPRA debate.
Trying to reconcile those competing interests, historical rights versus modern-day economic interests.
Exactly. And this plays out in their opinions on other parts of IPRA, too. Like, take the question of who owns the natural resources within these ancestral domains. Big debate there.
Right, so within these ancestral domains, who owns the trees, the minerals, everything beneath the surface? Who gets to decide how those resources are used?
Big questions. And honestly, IPRA itself doesn't give a crystal clear answer on this. That's probably why even the Supreme Court had different interpretations.
So even the highest court in the land, they couldn't agree on this one. Tell me more about these different viewpoints.
Well, you have Justice Panganaben, for example. He points out that the way IPRA talks about natural resources, it's actually pretty nuanced. He argues that it doesn't just hand over outright ownership to indigenous communities.
So they don't own the resources, but they have a say.
Right. Panganaben highlights parts of IPRA that give them the right to manage those resources, to benefit from them, even to negotiate if someone wants to explore or develop those resources.
So it's more like they're custodians of the land, they have a voice in how it's managed, but not absolute ownership, sort of compromise.
Yeah, you could see it that way. It's trying to balance things out, indigenous rights and the state's interests.
That balance, or lack of it, seems to be the recurring theme here. Any other noteworthy opinions from the justices?
Justice Kusaming, he really drove home this point about balance. He said IPRA shouldn't be an us versus them situation.
Not indigenous communities versus the state.
Right. He believed recognizing indigenous rights, it's actually a part of national development, not opposed to it.
So finding a way for both to coexist, to thrive.
Exactly. He saw IPRA as a way to create a more inclusive approach to development, one that respects indigenous knowledge and makes sure they're part of the decisions that affect their lands.
That makes sense, especially given the history we talked about, indigenous communities often being left out of decisions about their own territories.
Absolutely. And this is where free, prior, and informed consent comes in, FPIC for short. It's a big deal in IPRA.
Okay, FPIC sounds important. Break it down. What does it actually mean?
It means indigenous communities have the right to be consulted, to really understand what's being proposed, and crucially, to say yes or no before any projects happen on their ancestral domains.
So not just being told what's going to happen, but having a real say in the decision-making process.
Exactly. It's about shifting the power dynamics, moving away from a top-down approach to something more collaborative, something that respects their knowledge and right to self-determination.
This deep dive into GR No. 1355385, it's really revealing just how complex this issue is. Legal history, cultural clashes, economic interests, the fight for indigenous rights, it's all tangled up in this one law. But let's shift gears a bit. We've covered the historical context, the legal arguments, the different opinions from the justices, but what about the real-world impact? How does this all play out in the lives of indigenous communities? So we've got IPRA, this law that's trying to find that balance, recognizing indigenous rights, but also thinking about national interests.
Right, a delicate balance.
But we know laws on paper, they don't always translate smoothly to real life.
Yeah, the implementation, that's the real challenge.
So what are we seeing with IPRA? What are some of the hurdles?
One of the biggest. Proving ownership. Imagine your community has been on this land for centuries.
Generations and generations.
Exactly, but you don't have those pieces of paper, those written records that the legal system wants to see.
That's got to be incredibly frustrating. How do you even begin to document something like that? Oral histories, I imagine.
Oral histories are a huge part of it. Gathering those stories, those memories passed down through generations, mapping out traditional territories,
Piecing together the past.
and then trying to match those up with whatever land records exist, which, let's be honest, they're often incomplete, sometimes even inaccurate. It's a long process.
Time-consuming, resource-intensive, and I bet emotionally draining for those involved.
Absolutely, and that's not even mentioning the pushback IPRA gets, some people saying it's bad for development, slows things down.
Ah, yes, the classic argument, progress versus tradition.
Right, they say recognizing ancestral domain claims, it gets in the way of projects that could boost the economy, like mining, logging, big infrastructure projects.
A global dilemma, really, trying to find that balance between indigenous rights and economic growth.
And it's even more complicated in the Philippines. Many ancestral domains, they're in areas that are rich in resources.
So the stakes are high. How do you even begin to balance those competing interests?
That's the million-dollar question. IPRA tries to do it with things like FPIC, that free, prior, and informed consent we talked about.
Giving communities a voice, making sure they're really on board before anything happens.
Exactly. The idea is that if you have that genuine consultation, that consent, you can avoid a lot of conflict and maybe, just maybe, find solutions that work for everyone involved.
Sounds good on paper, but does it actually work that way? Has IPRA actually made a difference for indigenous communities?
It's a mixed bag, honestly. Some communities have seen real progress. They've been able to get their certificates of ancestral domain titles, CADTs. Think of it like a giant land title, formally recognizing their ownership of that ancestral domain.
So that gives them control, legal protection against anyone trying to take their land.
Exactly, but getting a CET, that's not a walk in the park either. It can take years, lots of paperwork, legal hurdles.
Sounds like the fight's not over, even with IPRA in place.
Not by a long shot. IPRA is a good step, don't get me wrong, a powerful tool, but it's not a magic wand. It all comes down to how it's put into practice, how the courts interpret it, and whether there's the political will to make it work.
It's bigger than just the law itself. It's about societal change, awareness, that commitment to justice.
Couldn't have said it better myself. This whole case, GR No 135385, it might seem like just a legal thing, but it's really about so much more, you know? It's about land, identity, the rights of indigenous people. It's about our history.
It's about who we are.
Exactly. And I think the big takeaway here, the thing I hope people remember is that IPRA, it's not just about legal technicalities, it's about people.
Real people, real lives.
Right. Recognizing that deep connection indigenous communities have with their land. It's not just about owning it, it's about their culture, their spirituality, their whole way of life.
It's about righting those historical wrongs, making sure indigenous communities have a say in their own future.
Absolutely. It's a long road, this journey towards justice, but it's one we need to keep taking.
This deep dive, it's been eye-opening. It's complex, yeah, but it's a conversation we need to have. Thanks for walking us through it.
Happy to be here.
And to our listeners, thanks for joining us on this deep dive. It's these tough, nuanced conversations that help us understand the world around us a little better. Until next time.